Good afternoon, everyone. This is Judge McBurney, and I am streaming this live over YouTube for folks who want to simply watch and hear, but for everyone else who ought to be here, this is an interpleader action. It is styled the Sheriff of Fulton County versus Ms. Hathorn et al. There are a bunch of potential respondents. It's case 20cv334762. And before we get any further, I'm gonna ask you to mute your phone or your device unless you're saying something. I'll be happy to hear from everyone who ought to be heard from in this matter, but it will work better if we've got everything muted because there's a little bit of background noise coming from someone. I'd like to start by effectively taking attendance, figuring out who is here for whom, and then we can get talking about what's going to happen with the money that is in the registry of the court. But it involves a tax sale, case does, from 2017 of 278 Hamilton E. Holmes Road. And there is about $33,500 that should be sitting in the registry that we need to figure out what to do with. So first, who is here on behalf of the sheriff?
Your Honor, I am Allie Jett.
Hello, Ms. Jett. How are you?
Hello. I'm doing well. Thank you. Yourself?
I am okay. Thanks for moving all this along. And then why don't we'll just work our way down. I've got a David Wood on my list of participants. Mr. Wood, good afternoon.
Yes, good afternoon, Your Honor. David Wood, I'm representing John Henry Scott, Jr.
Mr. Scott's lawyer is Mr. Wood. Okay, great. Then I've got an Joshua Foster.
Yes, Joshua Foster for the City of Atlanta, Your Honor. We also have a witness who is having some trouble joining the call. He's just texted me saying that it's not allowing him to join the meeting. Is there a way we can get him through?
I'm sure there's a way. You got through, and if he's got the invitation, you can see we've got 7 people who've gathered here. So I don't know what's obstructing your witness, but maybe someone on the IT side of the City of Atlanta could help the witness out.
I wasn't sure if there was someone actually letting each of us into the meeting.
The way the account is set up, I let people in, but I let everyone in. I reserve the right to kick someone out if they shouldn't be here, but there's no one in the waiting room right now.
Okay. I will get with him and be with you momentarily. Thank you.
Okay, thank you, Mr. Foster. On behalf of the city, I've got an Alicia Nair. I'm sorry if I mispronounced your name.
You didn't mispronounce it, Judge. It's Alicia Marie Nair, and I am here with Mr. Foster on behalf of the city.
Okay.
But
Are you the witness who's having trouble, or you're just part 2 of the legal team?
No, I'm more of the legal team. I'm an attorney with the city, just here for assistance if needed.
Great. All right. Thanks for being on standby.
Thank you.
We've got Chef Yvonne. You're on mute, ma'am, which I asked you to do. So thank you for being on mute. Now you're
okay. Yes, I'm Yvonne Hathorn.
How are you?
I'm super fantastic. And I guess I'm representing myself and my sisters.
Okay. So a couple things. You are free to represent yourself. If you are not a lawyer, then technically you're not representing your sisters, but I've read your answer and it sounds like the relief you're seeking is something that would benefit your sisters as well as the heirs. So I just want you to understand, I'll hear everything you've got to say, but technically you're not saying things on behalf of your sisters. You'd be saying things on your behalf, but it sounds like you and your 3 sisters are all similarly situated.
Yes. Well, I'll just speak for myself then.
Okay, great.
And
thank you for joining us. And thanks for giving us the fresh fruit backdrop. I like that.
Yes.
And Your Honor, I'm sorry to interrupt, but I forgot to say a minute ago that my client, John Scott Jr., is here in the room with me. And so If at some point his testimony is needed, I'm just going to point the computer at him and let him testify.
Sounds good. We'll do that. I think that covers everyone. Ms. Niles is my staff attorney, and she, like Ms. Nair, is sort of waiting in the background in case we need real smart people to weigh in about what's really going on here. But I think we can work through this. So let me explain where I think we are. There were a couple other parties, and I got notice today that one of the potential claimants, One Larkin Holdings LLC, they were not going to dial in because they were conceding that the city's claim was superior to theirs, and given the size of the city's claim due to an unpaid water bill, the One Larkin Holdings was standing down. So the lawyer for that LLC will not be joining us. So I think that's where we are. Mr. Foster, I want to give you time to get your key witness, but my thought is I'm going to start with Ms. Jett to just provide the setting as the petitioner here, and she may want to set forth what she thinks the legal fees are that ought to be paid if they haven't been paid yet. But then I'm going to turn to Mr. Foster to go first from the respondent side, because there is one of the largest water bills I've ever seen that is lurking out there. And if that is something that I sustain and it takes precedence, regrettably for everyone else, that's going to use up all the excess funds because someone didn't pay water bills for what I suspect was many, many years for it to have gotten that large. But we'll hear the evidence, and then we'll hear from everyone else. Regardless of what the city has to say, I'll certainly hear from everyone else. But Ms. Jett, why don't you get us started just by laying out, oh, hold on one second. There is a cell phone in the waiting room. Is that your magic witness, Mr. Foster?
Yes, that's Mr. James.
Great. Mr. James is trying to connect to audio, it says. Oh, and here comes the technical team. Well, I'm gonna let them work on that. Ms. Jett, why would you please just give us a little procedural background as to why we're here and what's in it for you?
Okay, very, very well. Yes, Your Honor, you did an ample job of kind of covering the basis of this case. So a little, this may be a repeat, but the Sheriff of Fulton County sold this property at 278 Hamilton E. Homes actually twice. This interpleader has to deal with a 2017 tax sale of the property that generated $33,539.78 in excess funds. You have previously entered an order authorizing the sheriff to deposit that money into the registry, and that has been done. On behalf of the petitioner, we ran a full 50-year title search to identify anybody and everybody who we thought might have an interest in those excess funds. And so those are all of our named respondents. And then as policy of the sheriff, they also like us to name sort of any and all who might have an interest. So it turns out that all of the individually named parties in this action either were personally served or acknowledged service, and in a rare instance in these kinds of situations, every single named party actually filed an answer. That does not happen often in my experience with these cases. So I don't think we have any issues of default. The only parties who were served by publication was we set up the unknown heirs of Gladys Clastel Scott as parties to the extent that the individuals named. I mean, we had some significant probate work that we thought gave us a pretty good idea of who all of the heirs might have been. But just as a base coverage, we published as against the unknown heirs, and then as to any unknown parties. It's been more than 60 days since the entry of that order for service by publication. The publisher's affidavit has been filed with the case. No additional answers from those unknown parties have been filed. Since this case was filed, I said every person that was individually named filed an answer. That is true, but one of the parties, Asset Recovery Inc., filed a withdrawal of their claim. And then, as you mentioned, Mr. Meyerson, on behalf of One Larkins Holdings, indicated that he was not going to participate there. But in terms of having everybody at the table that needs to be at the table, I think we've got everybody. I briefly mentioned that there was another tax sale of this property. I was not involved in that, but I think just for your knowledge about the background of this case, that might become relevant. But there was a 2019 tax sale of this property as well. So first, the property was sold in 2017. The person who bought it at that tax sale neglected to pay their taxes. And so then it got sold again in 2019. So, and that second tax sale generated $57,357.38 in excess funds. That property, those excess funds were dealt with in a separate interpleader, being a separate pot of money. I did not represent the sheriff in that action. Adam Caskey did. That civil action number, just so you know, is 2020 CV334762. And I reached out to Mr. Caskey earlier this week to figure out what the status of that case was. And actually a final order was issued in that case on February 4th, 2021. So I just I'm not involved in that case. I don't know a whole lot beyond that, the fact that the funds were dispersed according to that order, but I did want to let you know that backdrop to the extent that it became relevant.
Sure. Okay. This is fascinating. I've never had that happen before. Ms. Hathorn and Mr. Wood may be able to tell us a bit about that because they're listed as respondents there. Not sure why the city wasn't in the mix on that one.
Yes.
Looks like the money went to lawyers.
It looks like they were. The city's the last respondent in the caption of that case.
Yeah, no. I'm not sure why they got in the mix to say we want our $45,000. They were a respondent in the second tax sale. But money went to Mr. Caskey. A little bit went to something called Trot and Partners, as in $500. Then $51,000 went to Radcliffe Presbyterian Church.
And they were the purchaser at the 2017 tax sale that relates to our interpleader action.
Okay, so when the sheriff sold this property, in this case, the one we're here to talk about, the buyer was Radcliffe Presbyterian.
Yes, Your Honor.
Huh.
And then I guess they neglected to pay their taxes. I don't know if it's because they thought they were tax exempt. I have no idea as to why the taxes didn't get paid and there was a second.
Okay.
But apparently it did.
Understood. Okay, got it.
So the last thing I have on my list of things that I wanted to cover, and I'll get out of everybody's way after that, was just to talk about our fees. This case was a little bit more complicated than your standard with all of the various parties and their claims in this interrelation with this other case. But I have that we incurred $884.90 in legal litigation costs, including our title work, filing fees, service, etc. And then I gave myself an hour for today's hearing and any follow-up on a final order. And so with that hour plugged in, I have that our fees are $5,370. So that brings me to a total of $6,254.90.
6254.
0.9. 90.
Okay. Got it. Okay, thank
And
you.
that's all I have.
All right, thank you, Ms. Jett. Interesting case. So Mr. James is trying to come in again, Mr. Foster. He was now literally stuck in the waiting room, but I just let him in. So, and he's coming in on 2 devices. Maybe one has a speaker.
Yes, it looked like his audio was not working the first time he joined.
Okay, well, right now nothing's working. He's in, but there's no video or audio, but we'll see. Maybe the city should invest in a webcam for him. Is he a city employee or he's just some guy you want to have talk about the case?
He is a city employee. He's the collections manager for the Department of Watershed Management.
Got it. Okay. Ms. Jett's background was very helpful. This is a mysterious piece of property, and it's had a lot of court activity over the last couple of years. Probably these 2 cases should have been consolidated with the same judge. I'm sort of surprised that that didn't happen, but that's on the litigants and not on we don't look them up to say, wait, is there another case involving the sheriff? Because everyone has cases with the sheriff. But for Ms. Hathorn, for Mr. Scott, people who have had to go through this twice and are wondering what's going on, I'm sorry. Like Ms. Jett said, I haven't seen this before, where in such rapid succession of property bounces through these interpleaders. My hope is that whoever's in it now is paying taxes, so it can stay out of the courts for a while and paying their water bills. All right, if you think Mr. James is ready, my screen is saying he doesn't have any access, but I'm ready to hear from the city.
Okay, well, while he is joining, I will set up the background, Your Honor. We are here seeking recovery of a unpaid water bill in the amount of $45,251.07. This amount was incurred by Gladys Scott, the owner of the property prior to the tax sales. Mr. James, as the collection manager, will be able to confirm those amounts, but I can share my screen now with the water bill as well as the usage summary, if the court does not have those.
So I've got one thing, but hold on. I had to admit someone else now. There's a cell phone that ends in 0975. Is that you, Mr. James?
Yes.
Okay, don't go anywhere. You're hard to pin down. Is there any way you can get us video also? You're actually connected to this Zoom session 3 different ways.
I do have video, but I did not have audio, so I had to do the audio through the cell phone.
Okay. So can you give us a little video too?
Yes.
There we go. Fantastic. Okay. So Mr. Foster was just starting to talk about you as the heavy who does the collection. So he's going to probably have some questions for you. Mr. Foster, were there any exhibits that you wanted to have on the screen, or were you simply going to ask Mr. James questions?
I will pull up the first the water bill. This has been shared with the parties as well as the staff attorney, but it will be Exhibit 1. Mr. James, are you familiar with this document?
Yes.
Okay, could you tell us what this document represents?
This represents our standard monthly bill that will go out notifying customers of whatever is owed, being a current or being a delinquent.
Okay, and can you see the amount listed on the water bill?
Yes, the amount on this water bill right now is $45,251.11.
Okay, and who is identified as the customer for the water bill?
Scott is the individual that's identified as the custodian, the account holder.
Okay, and is this document kept in the regular course of business with the city of Atlanta?
Yes,
Okay.
yes.
Your Honor, I'd like Exhibit 1.
All right. Anyone have any objection to Exhibit C1 being made part of the record?
I do, a little bit. I have an objection.
Sure.
This water bill doesn't show the usage history. It just has the amount. I could create this without the seal. I could create this on my computer. It just starts from nowhere. Just all of a sudden here's this $45,000 bill.
So I've got the same questions, Ms. Hathorn. I'm going to admit it. I think it is what Mr. James says it is. I think Mr. James is in a position to authenticate it.
Okay.
But to your point, Ms. Hathorn, there needs to be a little bit more explaining where the heck did this giant number come from? Because it's not tied to anything other than in 2015, a bill was sent to Ms. Scott at this address saying you owe a whole lot of money. And that's all that says. It doesn't say more than that to all the reasons you said, Ms. Hathorn. So I'll admit C1 and I'll let Mr. Foster continue.
Thank you, Your Honor. I will pull up what will be Exhibit 2, C2. Mr. James, are you familiar with this document?
Yes, this is our billing payment summary, which identify bills mailed out, as well as late fees, as well as any credit that would have been applied to the account.
Okay, and can you tell me what the customer's name is identified in the summary history?
Again, Scott, which is the same as the name and address that's on the summary is the same as name and address that is represented on the bill.
Okay, and what dates do the summary histories cover?
This summary history starts at January 29th of 2008. And can you advance it to the bottom, please? And it goes all the way to December 28th of 2015.
And what is the total amount owed by reference to this summary history?
$45,251.11.
Okay, and
which is the reflective on the bill that was mailed out. So this is basically the backup to that bill.
okay, and could you explain to the court how these summaries are produced and how a water bill can get this large?
Yeah, let's talk about the 2010 bills. Something is like they were running white water out of the house for the year 2010.
So from February 24th of 2010 to January 28th of 2011, or should I say February 23rd of 2011, it seems like there was some form of leak on the property based on these dollar amounts that are representative here. Because as you can see, after February after 2011, the bill has come down significantly. So that means between that period of time and this period of time, that leak most likely has been fixed.
Okay, and is it your understanding that was brought to the city's attention?
No, it was never.
I couldn't hear what you said, Mr. Foster.
Mr. James, was there some indication that a leak was brought to the city's attention, or are you basing those numbers and the potential leak based on your experience?
I am basing that based on my experience. In a review of the notes, it appears that nothing was brought to the city attention as far as a leak, because if it was, what we would have done is get with the customer and try to find out how we can make some form of adjustment after that leak was repaired.
Okay. Does the city have a duty to investigate these types of expanded water bill numbers?
We do not have a duty that we must investigate, but we would in certain occasions. And when we send the bills out on a monthly basis, we also notify the customer that, you know, they have a unusually high consumption for that month.
Okay. And to your knowledge, the city was not put on notice of a leak or some other complaint regarding the usage?
Not to my knowledge, no.
In your position, is this document kept in the ordinary course of business?
Yes, it is kept in our system, which is called Inquester.
Okay. And at the time these bills are issued, they are due. Is that correct?
Yes.
Okay. Your Honor, I'd like to admit Exhibit C2 into the record.
Okay, are there any objections to admitting Exhibit C2? Okay, admitted.
Thank you. Mr. James, I understand that this bill represents a number that is quite large, especially for a residential property. Is that accurate?
Yes.
Okay. Despite the large number, is this money still owed to the city?
Yes, it is.
Okay. And I actually want to bring that bill back up one more time. I apologize. At the bottom of the bill, I see what is listed as W off. I'm assuming that means a write-off at the bottom of the bill.
Yes.
Could you explain what the city's write-off policy is and how these amounts were calculated?
Okay. If you look, it actually shows two amounts. It shows 13,291.40, which is representative of the water side, and then it shows 31,959.71, which represents the sewer side. Okay. So when you speak of the $45,251, you have to take into consideration is water and sewer that is encompassed of that entire bill. So when the city writes an account off, it's not a write-off like a credit card write-off or a auto write-off. It's basically just removing it from our books so that we can always have the ability to collect on these outstanding municipal debts.
And correct me if I'm wrong, what you're saying is the lien still exists, but this was an administrative write-off. Is that correct?
Exactly. So it was a lien by operational law.
Okay. We'll stop sharing this. And I have no further questions for Mr. James.
All right, well, let me see if anyone else does. Mr. Wood, do you have any questions for Mr. James?
Yes, Your Honor, I do have a few questions.
Okay.
All right, Mr. James, hi, my name is David Wood and I represent Mr. John Scott in this case. Wanted to ask you a few questions. And I'm looking at a copy of your bill. I don't have it to put on the screen, but do you have a copy of it there that you can look at while I'm talking to you?
Yes, I'm familiar with the bill.
Okay, all right. So first of all, the first entry on the bill says January 22 of 2008, and it says there's a balance of $1,929.91 at that time. But there's no information here about how that charge was incurred, right?
Right.
And I guess sitting here today, we really don't know. We have no way of knowing exactly how many months of unpaid bills that represents or anything. Is that fair to say?
Sitting here today, you're absolutely correct. And I could basically explain that. January of 2008 is when the city converted from one system to the next. So at that particular time, that's why it shows that $1,900 as a lump sum. But you know, as just like the details that you saw from the payment summary, we had basically the same details from another system that we converted from. So
okay.
we would just have to go in and do a little further digging in order to pull that summary out.
Okay, sir. So now I understand that you're the collections manager. I'm wondering, are you familiar with the Atlanta City ordinances that relate to non-payment of bills?
Yes, I am.
Okay. Now, sir, I'm going to share my screen here real quick. Let's see. Are you able to see this? Says section 154-120 non-payment of bills. Are you on your screen?
Yeah, I could see it.
Okay. So I'm just gonna talk about some parts of this, and it's in the very first paragraph. This is before the highlighted portions. It says the last sentence, it says the policies and procedures developed must contain at least the following provisions. You see where it says that?
Yes.
Okay, and then that first highlighted portion, it talks about how if somebody doesn't pay their water bill, then they're supposed to receive a notice of disconnection of their service. Are you familiar with that basic procedure?
Yes.
Okay. Then the very last sentence of the paragraph, which is highlighted, it says, in no event will the termination of service be later than 30 days from the due date of the bill for monthly bills and 60 days for bi-monthly bills. You see where it says that, right?
Yes.
Now you, obviously just looking at this bill, you have to admit that it's obvious that that was never done in this particular instance, correct?
Well, the notices have gone out on because on the monthly bills it states that the account is delinquent and that the services can be interrupted.
Okay, and so what I'm getting at is it's obvious from looking at this long list of bills that the service continued month after month after month and was never disconnected, correct?
Yes.
And obviously, if the service had been disconnected back in January of 2008, or even before that, after there had been 1 or 2 months of missed payments, we wouldn't be sitting here today looking at a bill for $45,000, would we?
Technically, I would agree with that, but one of the things that the city also look at is a situation on a residential property. We do not know who is in that property, and we do not know if there's a situation where that person that's in that property is elderly, or if that person needs water service because of a medical issue.
Okay, now I'm going to, let's see. Let me see if, okay, I'm now sharing a different screen, which says section 154-59, authority to prohibit waste of water. You see that?
It's
Yes.
not being shared yet. You were still
No,
got
it's not being
120.
shared.
Sorry, let's see. How do I do this? Oh, new share. Sorry.
It's okay. We're all learning the technology.
I'm still somewhat of a novice at this. Do you see it now?
Bingo.
Yes.
Okay. Okay, sir. So in this section, are you, first of all, have you seen this section before? Are you familiar with it?
Yes, I've seen it before. Yes.
Okay. So essentially what it's saying is Commissioner of Department of Watershed Management or the commissioner's designated representative shall have the power to take whatever reasonable and lawful steps are necessary to prevent the unlawful use or waste of water, right? That's what it says.
Right.
Okay, and so as we were talking about a minute ago, in the early part of 2010, as you said, there were significantly higher monthly charges that started happening, which in your mind indicated that at least likely there was a leak, correct?
Right. And that leak could have been in a couple different form. It could have been a situation where they had a toilet that was running. It could have been a in between the wall leak. It could have been an underground leak. We the city has no way of finding that out because we're prohibited from going on private property. So we normally look at the owners or the tenant to notify us of that leak so that we can then look and see what we can do about making some adjustments after they have gotten that leak fixed.
And doesn't the city at some point in some situations like this actually go to the property and turn the water off in order to keep it from continuing to leak extensively like this?
Yes, we would.
Yeah. Okay. But obviously that wasn't done in this case either, right?
Based on that years we're showing significant consumption. No.
And it looks like, looking at your bill, it looks like that the water was actually finally shut off approximately March of 2011, something like that, right?
Yes. And that could have been from a couple of different things. It could have been we got a notification from the owner. It could have been that we went out to the property and we saw that the property was vacant.
Okay. Okay. Thank you, sir. Now, Your Honor, I do not have any more questions for this witness. I just wanted to let you know that earlier today, I had emailed copies of these sections to Ms. Niles. And so just for your information in case you needed them. So.
Thank you. I got them. They're in. Ms. Niles is great in setting up a little folder for each case. And inside the folder for this case are your ordinance
All right, very good.
excerpts.
Thank you, sir.
I've got a question for Mr. James, and then I'll see if anyone else on this hearing has questions. So, Mr. James, Mr. Wood was asking you about water shutoff. And if we look, if you, well, I'll share my screen and I can guide us to it. Can you stop sharing your screen, Mr. Wood? Thanks. All right, Mr. James, we're back to C2. That's the city's exhibit. This is the itemized bill. And let's see if I can. Looks like right around here, the bills drop dramatically or drastically, combine those two words. So a couple of questions. One, we see for a few months a bill of about $12. And then there's the late pay, but I'm focused on the bill. What does that say to you, given your expertise and your position? I mean, that's what's going on there.
So that $12 would have been representative of what we deem as a line charge. So after the account has been shut off, then what is charged is basically a line charge. And that's usually between $12 and $13 is what that is on a monthly basis.
Okay. So then it looks like as Mr. Wood was pointing out, in either late February or early March 2011, someone went out there from the city at the street side and cut the water off.
Yes.
Okay. There are no line charges as of September 2011, but the bill goes on for a while longer before it's written off. Any explanation for why there are bills being generated? Presumably that means that there's something being sent to 278 Hamilton Homes in January, February, March 2012. It's got this gigantic number on it. The number's just not growing.
Right. So that was, and I forgot when this was actually charged off, but that would have been at the time that we were in the process of moving this account to our charge-off state.
Okay. But there would be, if I were living at 278 Hamilton E. Homes, each month I'd get a dreaded letter from Watershed Management saying, hey, by the way, you owe us $45,251.
Exactly, yes.
All right, last question from me. Mr. Wood showed you some language about steps the city can take. Is it your understanding, and if this is not your role with Watershed, just tell me that, is it your understanding that the city must shut the water off if someone is delinquent, or that they have the power to do that should that be the remedy they want to pursue?
They have the power to, if that's the remedy they want to pursue. And just like I stated earlier, we don't know who's in the property, and we don't know if it's an elderly person or someone that needs the water for medical reasons.
Okay.
So we'll try to err on the side of caution sometimes, and sometimes we get burned doing that.
Okay, like we've seen during the pandemic, where the mayor has been very vocal, understandably so, about saying we're going to be real thoughtful before we shut off any utilities, because people's ability to pay during the pandemic may be compromised by events far beyond their control. Okay.
Exactly.
Ms. Hathorn, do you have any questions for Mr. James? All right, I put you on mute because there was some background noise, but I think you can unmute, and then you are free to ask Mr. James your questions. Hope I didn't break anything.
Okay, here we go. I'm sorry. Yeah, I have some questions and a couple comments. I have been in all the cases. This one, this one, and the other one, the 57,000K. So I can share a little bit more information. One of the things I would like the city of Atlanta to know is that in my motion for, in my answer for the summons, I included my aunt's death certificate, who was Gladys C. Scott. She died June 7th, 2007. So she didn't get any mail. She didn't get it. She was dead. Okay, I put her death certificate in my answer. The Radcliffe Presbyterian Church is right next door to that property. And they cut the grass, they had access to it, or whoever paid the taxes for this, for our case, sort of took over that property. They thought it was theirs. We thought it was theirs. We thought we were out of it. and then they didn't pay their taxes. I have a motion for interpleader relief for that case, in which case the city of Cleveland disclaimed their rights to the excess funds. They had an opportunity to get that bill paid with that $57,000, and they excluded themselves from that. The water, I've seen in city council meetings that I attend, I've seen the corroded pipes in Fulton County. So I know there is possibly a leak. I don't know who was maybe squatting in the property, because my aunt didn't have any children. I just relocated to Atlanta in 2015. So I was in Cleveland, Ohio. 3 of my sisters was in Ohio. So nobody was in the house, so nobody got any notices about the bill. I was wondering why the city of Atlanta backed out of getting their money, why they just decided to disclaim their claims to that money. And if they disclaim they got that money for that case, then how can they come back and say, okay, you owe the bill? And my aunt is deceased.
Do you have I'm looking at the file for the other interpleader, the one that Judge Cox handled. And it's not jumping out at me that the city did what you said. I'm not doubting you. I'm just trying to read the document.
Oh,
if you have
yeah.
a copy of it, do you have the date that it was filed?
Well, the motion for interpleader relief was filed on November 30th, 2020. I just have
Okay.
I just have it here with me, but I don't have the actual e-filing that they actually said that they're getting out of it.
Okay, I'm reading what you're reading, and there is a line on the second page of the motion from
Yes.
Mr. Caskey that says City of Atlanta disclaimed rights to the
Right.
excess funds. Okay, well, I'll have, I don't know that Mr. James is the right person to answer that, but certainly Mr. Foster can shed some light on that. I'm not saying, Mr. Foster, you were involved with the other case, but you're going to need to speak on behalf of the city as to why it wouldn't have stepped in there. I think it's entitled to collect on this bill in some amount, and we'll work through what that is in either case. And it may be that it had already staked a claim in this one, but it's a fair question. Did you have questions though, Ms. Hathorn, for Mr. James? Or
Yes.
because you provided some real helpful background, I now understand why Radcliffe Church is interested in all this. They're the next door neighbors, so
Yeah.
that adjacent property is valuable to them
I
if
have
they pay the taxes.
Yeah, I have a question about, I think Mr. James said that the leak was fixed. Who fixed the leak? And when was that done? I guess the bill dramatically went down, but if you had driven by the property, you wouldn't have to go on the property. You could see it was boarded up, it was abandoned, the grass was high. I mean, Radcliffe or that church took care of cutting the grass and getting rid of the debris in the back. So we assume they owned it, and they assume they owned it. But now there's a summons on that property for a quick title. Somebody is trying to get the deed and I guess get the house. So City of Atlanta had their chance and they could have driven by. It's been boarded up. It's been empty for years. I just want to know who fixed the leak.
So Mr. James, you want to talk about that a little bit more? Because I think I've heard two different things. One was that there was a leak. That's what those very, very high bill amounts represented.
Okay.
But then also that it was shut off, which may be why the leak stopped. Because the bill dropped from $2,600 to the line fee of $1,172.
Right. So what I said based on my experience, that in looking at those numbers, I said there was probably a potential leak that was there. And with the numbers coming down, I said it would appear that the leak was fixed. But it also could be a situation where the water was shut off also. So that's why we were only being charged. That's why they were only being charged a line charge. And the young lady's name is Miss Radcliffe. What's her name?
No, I'm Yvonne Hathorn, Radcliffe
Miss Hathorn.
Presbyterian Church on, pay the taxes or got the $57,000 or $51,000. They have their money dispersed.
Can I pose a question to Ms. Hathorn, Judge?
She doesn't have to answer it, but she's free to listen, and if she wants to answer it, she can.
You said that your grandmother passed away.
It's my aunt.
Was your aunt? Was the city ever notified that she passed away?
I have no knowledge of that. As I
Sounds
said,
like Ms. Hathorn and her sisters were in Cleveland,
yeah,
and not here in Atlanta. Ms. Hathorn has recently returned or come to Atlanta.
Yes, come to.
But it sounds like they were not active in a sense of being present in Ms. Scott's life back in 2007.
All right. Well, thank you.
Okay. Mr. Wood, I've got a question for you, and then we'll get back to see if anyone else has questions for Mr. James. Can you help me understand the family structure? Ms. Hathorn and her three sisters are nieces of Ms. Scott, who, according to Ms. Hathorn, had no kids. You represent Mr. Scott. What is his connection to Gladys Scott?
Correct. None is the answer to that.
Okay.
So,
Exactly.
so just real quickly, if we look back to, there's a deed which is attached to the petitioner's complaint from back in 1961, deeding this property to two people. One is John H. Scott, which is John H. Scott Sr., who was the father of my client. And then the other is Emma Scott, who's the sister of my client. John H. Scott is the person, senior. We are not claiming through him. We are only claiming through Emma Scott, okay? John H. Scott later on died and left his interest in the property to his wife at the time, Gladys Scott. And these 3 or 4 women, including Ms. Hathorn, are claiming as heirs of Gladys Scott, who was an heir of John H. Scott Sr. That said, Emma Scott's property interest was never sold or otherwise alienated. And
so Emma Scott would have a half interest in the property. And so your client, John Scott Jr., or the second, according to your theory, would have a half interest in the property. And really, again, according to your theory, Ms. Hathorn and her 3 siblings would be dividing up a quarter each Gladys Scott's half interest in the property, because she could not inherit more than what her husband could give her, which was half of the property, according to the paperwork you've got.
that's exactly how I see it, yes.
Okay.
Yes.
Okay. That helps me just understand why we've got a Scott in the mix, and then we've got Ms. Hathorn and her 3 sisters who are nieces of a Scott.
And Your Honor, that's exactly why whenever we did our title work prior to doing this, we went, like I said, we did a full 50-year search and went back further than just the deed into Gladys, and had the concern through looking at the several in both the senior and Emma probate work that there was perhaps some lingering interest out there. So we weren't entirely sure, and I always try to over notice rather than under notice in case there was, just like apparently there is, some lingering.
Got it. So Ms. Hathorn, just so I can try to understand the family tree, your mother or your father was a sibling of Gladys Scott?
Yes, that's correct.
Okay.
And in my answer, I submitted my mother's death certificate, my aunt's death certificate, and both of their wills. I also have John Scott, my uncle's will, that was filed on June 13th of 2020. It has the warranty deed that gives everything to my aunt. I wasn't aware that my uncle had a son. So Gladys Scott made her will out willing everything to her only sister, Doris Marchman.
And that's your mom.
That's my mom. And then my mother's will is separating all her interests amongst her four daughters.
Okay, got it. So what you may not have known about, and we'll have to look at what all the paperwork is if we get to this point, is that I think I'm getting the titles right. Your uncle, John Scott Sr., did have a son, and somehow this piece of property at some point was partly his, but also Emma Scott's, and it's the Emma Scott interest that connects the John Scott who's on our call, represented by Mr. Wood.
Okay, so Your Honor, okay, I see he submitted that. It's just the indenture. It's like not what is the document that was submitted? I guess this is Exhibit 1 for John H. Scott. I can't, you probably can't see this, but it was on, it's the only thing that has John Scott and Emma Scott's name on it. What is that? That's not a deed, is it? I mean, I'm not exactly sure what it is that ties them together. Like they own the property together. I'm not sure.
So what you're calling JHS1, we're looking at the same thing here. Let me help out just so I think we're talking about the same thing. This document, is this what you're talking about? Ms.
Yes.
Hathorn?
Yes.
Okay. So why don't you, Mr. Wood, narrate this document for us?
Yes, sorry. So this is where a person named Henry Stargell sold the premises to and deeded it over to John H. Scott and Emma Scott back in 1961. John H. Scott being in relation to my client, his father. However, as I mentioned, we're not claiming through John H. Scott, we're claiming through Emma Scott, who was my client's sister, actually half sister. And she died intestate, and my client was the only intestate heir, and is therefore making claim through Emma Scott.
Okay, so Ms. Hathorn, I am not a property lawyer, and I'm not giving anyone legal advice, but this is part of the property records for 278 Hamilton E. Holmes Road, your aunt's former residence. And it creates an interest for Emma Scott that unless you've got paperwork, and I'm not saying it's not out there, but if you've got paperwork showing that Emma Scott gave it to your uncle or gave it to your aunt, her half share in the property goes somewhere. And Mr. Wood is saying because Emma Scott died intestate without a will, then it would flow to any of her siblings, of which there appears to be one. The gentleman on the call, you can't see him, but he's in the room with Mr. Wood, John H. Scott Jr.
That would be her nephew.
Whose nephew?
Emma Scott. I'm
My
trying to
understanding is
understand.
that's his sister.
Okay, I'm confused because John H. Scott is my uncle, but who is the guy that's in the room? How is he related to Emma and John Scott, my uncle?
What Mr. Wood said to me was that the gentleman in the room is the sister of Emma and the son of John Scott.
There's nephew.
Brother of Emma and son of John.
I'm sorry, right, sibling, right, brother of Emma and son of John. So the John H. Scott on that piece of paper and Emma Scott are not the same generation. They're a different generation.
Okay, so that's that. Okay. All right, so I have a document where Emma Scott left her estate to this guy in the room for about $20,000. That was in the 57-year certificate of title that my sister and I purchased from Augusta Title and gave to Ally Jett. So I got that document from the certificate of title. So we were trying to figure out if Emma died without a will and he got all of her property and therefore has satisfied his claims to anything. And I'm not a lawyer either, so I don't have I just try to read everything I see.
Got it. And you should read everything, and you may want to consult a lawyer about how Emma Scott's property interest in your aunt's property would flow. Mr. Wood has given his assessment of how it would flow and why he believes it flows to his client, which is Emma's half brother. And I follow his reasoning. If you end up with any official paperwork, a deed where Emma Scott says, no, you know what, I'm transferring my interest to my uncle, John H. Scott, or I'm transferring it to whomever, we can consider that. I don't have anything in the record in front of me that says Emma Scott ever gave her interest in your aunt's property to anyone. And so when she died, it had to go somewhere. And Mr. Woods explained to me where he thinks it goes.
So I have two questions for you, Your Honor, if that's okay.
Sure.
All right, so if it goes someplace, so I would need a deed, a quitclaim deed or a deed from Emma Scott to my uncle to prove that she gave her rights away to that property. And then second,
to that person, if she gave her rights to someone, there's a document showing that she did it.
Okay, so she didn't, so we're just back to kind of square one.
You got what you got from paying for a title search, which was smart. And it sounds like what you found in that title search, well, what the title search people found and gave to you, and then you gave to Ms. Jett, it did not show that Emma Scott ever transferred her interest to anyone. She got it, she held on to it, she passed away.
Okay. My second question is, what is the purpose of the will? So if John Scott willed everything and the property to his wife,
he can only give what he has. So if he has half an interest in the property, which is what we're on the screen, what we're looking at here, says that your uncle had an interest, but he can't give away Emma Scott's interest.
Okay.
So he gave to his wife, your aunt, everything he had, which was a stake in the property, but not a 100% ownership stake.
Okay.
Does that make sense?
Yes, it does. Thank you.
Thank you. I'm learning a lot. Usually these interpleaders aren't as complicated, but it sounds like this little piece of property was important to some folks, and then sadly for a while it sat all alone with the church, maybe doing a little bit to keep folks out of it, and the ground's looking okay. All right. Does anyone else have questions for Mr. James? He's been sitting there very patiently. Did you have any redirect, Mr. Foster?
I just have one or two more questions, Your Honor. And if you don't mind, if you would, there we go.
Give you the screen back.
So I can see everyone else. Mr. Scott, or excuse me, Mr. James, the bills we looked at show usage from 2008 to 2011, I believe you testified. Is that correct?
Yeah, based on the summary that you showed, yes.
Okay, so the city provided water services to that house for that time. Is that correct?
Yes, for that period of time. Yes, you're correct.
And the city is owed for those services, correct?
Yeah, absolutely correct.
Okay. And without a indication or notice from the customer, the city chose to continue providing those services. Is that correct?
Objection leading.
Okay.
Mr. James, did the city provide services to that customer for the periods that are indicated by the bill?
Yes.
Okay, thank you. No further questions.
All right. Anyone have anything else for Mr. James?
I do not.
Nope.
I
All right,
do.
Mr. James, I appreciate you dialing in.
I
Well,
do.
thank you.
Oh, I'm sorry. Don't go
Yeah.
yet. Ms. Hathorn.
Yeah, I agree. I know that the city is entitled to that money, but I think they should get the right person who used the water. And I was just wondering why they didn't get it from Radcliffe Presbyterian when they had enough money to cover the whole bill. I just would like to, I guess, bring that back up to the.
Okay, and I think that's a fair point. And I meant to have Mr. Foster explain sort of procedurally what the city's approach was. Mr. James, you do not need to field that question because that's a lawyer question. Someone on behalf of the city represented to the lawyer in the other case who's playing the role that Ms. Jett is playing here, that the city wasn't pursuing anything in the other case, which is of course the same property for which the same lien to the tune of $45,000 was in place. Any reason you know of or reason you could give as to why the city said no thanks in that one, but is pursuing this one? Because if you get everything in this case, you're not getting everything your bill suggests you're entitled to, whereas in the other case, you could have been paid in full.
Your Honor, at this moment, I don't have the answer to why we chose to pursue this one and not the other. If you could give me the CV, I could possibly pull the records to understand, but I think the most simple answer is we answered in this case and decided to not pursue it in the other.
Okay. So, Ms. Hathorn, that is not going to let you sleep well at night, that particular answer.
No, it's
And
not.
sometimes there's not a great answer. These interpleaders pop up all the time. At one point, I had to ask my colleagues if for some reason I was getting all the interpleaders because it seemed to be all I was doing. And the other judges said, no, we have the same number you have. Because there were so many distressed properties, and it goes in waves in the late 00s. And then again, because of all of the dislocation caused by the pandemic, we get these things all the time. And it is hard for everyone to keep up. It looks like the city missed out on an opportunity to get wholly compensated in the other case. That said, they're not obligated to pursue it at all. I mean, you heard what Mr. James had to say. We can turn the water off. We don't have to turn the water off. We can write the bill off. We don't have to write the bill off. It's just, that's not an answer that's going to make you and your sisters feel particularly happy.
I have a question though, Your Honor.
Yeah.
I have a question. Is there a way that we can get an answer for that question before things are settled as to why they didn't, or
Well,
is there any way to get it, or are
I
they going
don't
to
know how
answer
it would
it?
change anything.
Okay,
There's not an answer that would undercut the city's ability to collect here.
okay,
What wouldn't be okay is if the city had gone before Judge Cox and said, hey, we're owed 45 grand, they collect, and then they come knocking here as well.
Yeah.
Then you'd be in a
Double dip.
position to say, wait a second, they got their relief. They don't get to get it twice from two different pools of money.
Okay.
All right, Mr. James, I appreciate your time. Thank you for dialing in. Thank you to your IT team there at home, helping you figure this out. Okay.
Thank you.
Thank you,
All right.
Will.
So, Mr. Foster, you've made your presentation. Anything else you want to add before I turn to Mr. Wood?
No, Your Honor. Thank you.
Okay. Mr. Wood, are there any witnesses you want to call or any argument you want to make beyond what you've already presented through the city's witnesses and then your gracious explanation to me and others as to your client's connection to the case?
A couple things. Yes, I have my client here to give testimony for the record, just, you know, in support of his case. And then also, before we close out the day, I would like to be heard for argument in connection with the city's claim.
Okay,
Whichever the court would rather hear first is what.
let's hear from Mr. Scott first, please.
Okay, very good. I'm going to just turn the computer around here so that we can see, so you can see Mr. Scott. Say hello, Mr. Scott.
Hey, how you?
Hello, Mr. Scott.
Okay, now, Mr. Scott, will you please raise your right hand? And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you, sir. First, will you please tell the court what is your name?
John Henry Scott.
And are you a junior or a senior?
John Henry Scott Jr.
Yes, sir. Okay. And what was the name of your father?
John Henry Scott.
Was he senior?
Senior.
All right. And did you have a sister or a half sister?
Yes.
And what was her name?
Emma Scott.
Okay, sir. Now I'm going to do a share screen here. And I'm going to, let's see, where did I have the, well, okay, well, I am not exactly sure how to do that. So I'm going to, let's see, exit from that. So we provided JHS 1 and 2. Does everybody have those? Just so I could maybe avoid the sharing screen.
I can put them up on the screen just so
Okay.
everyone's looking at the same thing.
Okay, thank you very much. I couldn't, there's something about the way my computer is set up that I wasn't able to do that, but so.
All right, here's JHS 1.
Okay, yes, sir. Okay, so you see on here, sir, on JHS 1, where it says it's this property is deeded to John H. Scott and Emma A. Scott. You see that?
Yes.
And John H. Scott, is that your father?
Yes.
And Emma Scott, is that your sister?
Yes.
And sir, this is in 1961. First of all, let me ask you this. What year were you born?
1942.
And your sister, was she older or younger than you?
Older.
About how much older?
About 10, 15 years.
10 or 15 years?
old. Yeah.
So if you were born in 42, then maybe she was born in either the late 20s or early 30s?
I would say so.
Okay, so it come 1961, she might have been around 30 years old or so. Okay. Now, sir, if I'm going to ask you to look at what is marked as JHS 2, exhibit JHS 2. And I'll just ask if you can identify what is that document.
I can't see that well.
Is that a copy of your driver's
Yeah,
license?
copy of the driver line.
Okay, and that's you pictured there, right?
That's my picture.
Yes, sir. Okay, very good. Now, Emma Scott, your sister, is she still alive?
No.
Okay. She died, and at the time that she died, are you aware of any other brothers or sisters she had?
No.
Okay. All right, sir, that's all the questions I have.
Let me see if anyone else has questions for you. Mr. Foster, any questions for Mr. Scott?
Oh, Your Honor.
Ms. Hathorn, any questions for Mr. Scott?
Yes, I'm trying to understand the family tree. Like John Scott was married to your mom, or who is your mom? What's your mom's name?
My mom. Zadie Scott.
Jane?
Zadie.
Okay.
Can you spell the first name?
I think it's Z-A-D-D-I-E, I think.
Zadie?
Yeah, Zadie.
Okay.
Did you say Zaddie?
Yeah.
Yeah.
Okay. So John Scott Senior, Zadie, and then Emma Scott, your half sister,
Yes,
and you. So
yes.
Emma's father is somebody else,
No,
or Emma's mother?
Emma mother, Emma had different mother. I had same father.
Okay, same father. Okay. All right. Yeah, find the deed.
Ms. Hathorn, anything else?
I think that's it.
Okay, you're expanding your family tree.
Yes.
Okay. All right. Mr. Wood, anything else?
Your Honor, we just, we moved to admit exhibits JHS 1 and 2.
Any objection, Mr. Foster or Ms. Hathorn, to admitting JHS 1 and 2?
No.
Okay, they're admitted. All right, Ms. Hathorn, is there any evidence you want to present or any witnesses you want to call beyond what you've already shared?
No, no, everything that I have showed up in my interpleader answer. I do understand that the will, he can only give his half to his spouse. So I get that.
He can give whatever his interest is. And so, like I said, if you stumble across something that shows that Emma Scott gave things back to her father, then he would be in a position to give more than he did. But that deed that you and I have seen means that your uncle did not have the ability to give total interest in the property to your aunt. He just gave his stake in it.
I see.
All right.
Okay.
Well, Mr. Wood, you said there was some argument you wanted to make. I'm happy to hear that.
Okay, great, thank you. Okay, so first of all, looking at the city's bill, as we discussed, the first entry just shows that there was already a balance at the beginning of this itemized list of 1,900 and some change. And as pointed out in the questioning, this represents some period of time prior to the issuance of this bill. I would put forth, just looking at the numbers that were the monthly amounts around that time, you know, 150 and 200 and so on. This probably represents about a year's worth of unpaid water bills. Now, and this is to go directly to Your Honor's question to the witness, where the court asked the witness if the city had any duty to go out and turn off the water, and the witness responded no. And so looking at the section that I had submitted on non-payment of bills from the city ordinance, and I'm looking at paragraph 1 under there, and it's the very last sentence of paragraph 1, and it says, in no event will the termination of service be later than 30 days from the due date of the bill for monthly bills and 60 days for bi-monthly bills. So it very clearly says in the ordinance that this is mandatory, that in no event will termination of service be later than 30 days. So therefore, based on the evidence that we have seen, the city was in violation of this ordinance, and they were actually in violation of this ordinance. We can extrapolate even prior to the first item on this bill, because presumably after a month or two of unpaid bills at approximately $150 a month is when the service should have been shut off. But it wasn't shut off. It never was shut off, and obviously should have been. And also what the witness had testified to was that, well, sometimes, you know, maybe there might be some kind of medical reason or something like that. But we've also heard from Ms. Hathorn that her aunt, whose name is Gladys Scott, who's the one on this bill, had died in 2007 So in other words, she wasn't even alive or there at the property, and yet the city continued to provide water service and never shut it off after bill after bill after bill was not paid. And then it even got worse when it's obvious what happened was that a leak started to occur in 2010. And again, despite these huge water bills, which went from $150 a month up to first $1,000, then $2,000, then $3,000 a month, the city still never came out and shut off the water. So when the city is coming forward and they're claiming and wanting to claim against the heirs for this $45,000, my response is that the city was negligent in this case and they caused the problem themselves. And they caused the problem. Not only were they negligent, they flat out violated the ordinance that's there. And so having violated the ordinance, I would submit that they have no legal right to recover this $45,000. And really all they would have the right to recover, if we even saw what these charges which predate this event, this bill, all they'd have the entitlement to recover would be maybe the first month or two, after which is the time when they should have shut off the water. So that is, in addition to that, I mean, it's clear to me what happened finally in February of 2011 is finally they went and shut off the water, because the 3 months right before that were bills of $3,000 and some change. And then all of a sudden the bill's down to $2,500. So what I would say is they came out and shut off the water, you know, a couple of days, 2 or 3 days before the end of the month billing cycle. And that's why it's a little less. But I mean, that's sort of neither here nor there. Point is the water based on the ordinance should have been shut off, you know, a few years before. And if they had followed the ordinance, we wouldn't be here arguing about this. So,
Okay.
So we absolutely oppose the city's claim really in its entirety for that reason. Although I think it would be fair to give them a couple of $100s for a couple of months, but we don't even know what those amounts are because that evidence wasn't presented.
So, Mr. Wood, if I follow your argument and am persuaded by it, what is your position as to your client's share of the proceeds? My math was that it would be whatever's left, if whether the city gets a little bit or a lot, whatever's left. The way I was following the family tree and your argument is that actually Mr. Scott Jr. would be entitled to half of the proceeds.
That's exactly right. We contend we're entitled to half of everything that's left over. So yes, and that the Ms. Hathorn and her sisters or other claimants are entitled to the other half. Okay.
All right. Thank you. Ms. Hathorn, tell me your thoughts beyond what you've already shared.
I think we're entitled to it all, but since the you know, he came up with the deed, and you explained to me that he can only give what he had, and I understand that when my father passed away, my mother got a portion and then all of us got a portion. She couldn't get the whole thing. So I'm okay with that. I'm okay with the attorney fees, Ally Jet's fees being paid, the half, and then the other half split between my the four of us. I'm okay with that. I am not okay with the city of Atlanta's claim because they, like the lawyer said, they neglected to turn that water off and they don't have the right person. The owner of that property is dead. And I don't know who was in that house since I was out of town. So I'm okay with the way the attorney broke it down.
Okay. So I want to make sure, I think I heard you say this early on, when you and your sisters, or at least you, reviewed everything that came out of the title search, you saw that deed that has your uncle's name and Emma Scott's name, or had you never seen that before today?
No, it's in the title.
Okay.
But there's so many things in here. I'll have to go back. Now that I know what I'm looking for,
Sure.
I'll have to go back and see if I can find it.
Yeah, and it's hard to figure out what the different things mean, and the further back you go, the harder it is to read the things because they're bad copies. But I'm more comfortable now. I just wanted to make sure, because I thought I heard you say it. You had seen that document. You may just not have appreciated exactly what it signified.
Right. Yes, that's correct.
Okay, got it. All right, thank you. I understand your position as well. Mr. Foster, what do you have to say about Mr. Wood's argument that Ms. Hathorn echoes, that the city actually was obligated to cut off service, and because it didn't, bills that accrued after that obligation was triggered ought not to be payable through these excess funds?
The city's position is that there is no such obligation to cut off water bills. Rather, we have the ability to do so. And in practice, the city operates as if that provision states the opposite. We will not cut off or terminate service earlier than 30 days of the due date of a bill. And that application, the one that we actually utilize, comports with the fairness and equity. Because if we did take Mr. Wood's position, every customer in the city of Atlanta who goes into arrears would have their water terminated. And an unprecedented number of Atlantans would lose their water if we were to act in the way that this provision states. I will note that the provision is an address to the Department of Watershed to come up with policies and procedures. It is not in itself a mandate that they do specifically what is Mr. Wood's position. But we believe the city has acted fairly in continuing service and billing people for those services. And it is the city's position that we are owed for those services.
Okay. Thank you. Ms. Jett, anything you want to add? I think you got out everything you needed at the beginning.
I mean, Your Honor, I don't have a dog in the fight, and I think the sheriff generally feels like it's inappropriate. I mean, I always have opinions on everything.
No, and that's not what I was asking. I want to be clear. Your client takes no position in any of this. Your requests were: 1, please put the stuff in the registry. Done. 2, pay the lawyer's fees. And 3, please hold my client harmless for anything else that may flow from this. All we did was do the tax sale and collect the money. I just want to make sure if there were procedural things you needed to have taken care of today beyond what we already discussed, you had a chance to bring them up.
I appreciate you giving me the opportunity, but nope, that's the sum total of my list.
All right. Well, I appreciate everyone plugging in. I will take this under advisement. I will enter an order making clear what is going to happen with the funds that are in the registry of the court in connection with this case. Ms. Hathorn, I'm sorry you've had to go through 2 of these. These aren't real fascinating. You've had to do 2. And so far as you're helping your sisters out, they should thank you for the time you've invested in all this. Mr. Wood, thank you for getting your client involved. Did you have any connection to the proceedings in front of Judge Cox?
No.
Okay. All right. And Mr. Foster, I don't know if you're being evaluated by Ms. Nair, but you did a great job. So thanks for getting Mr. James here. And I will get this order filed. I know Mr. Wood and Mr. Foster, you have been e-filing. Ms. Hathorn, I think you've been e-filing as well. You will get electronic notice. We don't need to mail it to you.
No,
Great. Okay. All right. Well, thank you, everyone.
thank you.